Launched the recording. Yes, so warm welcome once again, and Kostas, the floor is yours. Okay, thank you.
Thank you very much. Good evening from me. I can hear me. Good evening. I'm honored to be here. Thank you for the invitation. I am representing today Euglottia, which we are working with patents, and I am a European patent attorney. So, as a European patent attorney, I will present you how we can work with patents and what's a patent, how we can use a patent to protect our inventions, and what's the procedure for a patent, how to evaluate a patent to see how much it will cost and what will bring back to sharing money, and how much should we invest in patent. I'm going to share my presentation. Just 1 minute, please. So, can you see my screen? Is it okay?
Yes, we can see Kostas.
Excellent. Okay. So, I'm going to talk about European patent. What's a European patent? How to protect an invention through patent. Okay, there are many intellectual property rights, different intellectual property rights, protecting different matters and different subject matters. For example, patents and utility models are for invention. Industrial designs are for a design, industrial design, like for example, for a machinery or for a bag. Trademarks. Trademarks is a sign that it is used in order to consumer to remember a company and to buy this type of products. That because these trademarks connect, for example, with quality. Copyrights are used mainly for artistic works. Domain names, everybody knows something.com or .eu. Geographical indications, if it is a product coming from a specific location. And of course, trade secrets, which something that nobody knows because the company that has a trade secret keeps it as a secret. So all of these are intellectual property rights. I'm not going to enter in detail in this. I'm just going to talk and focus on patents. Concerning patents, there is a public contract. What is this? The inventor discloses an invention. So he has discovered how to make a new medicine. So he writes this recipe, this formula for this new compound, and this is published to everybody. So it is disclosed to the public. Everybody knows how, after a while, knows how to prepare this type of medicine, this type of active compound. But on return, the inventor receives the exclusive right to use it for a limited period of time and for a specific reason. So this means that if it's a patent, for example, it's for 20 years, and let's say that it is protected for this area. So the inventor discloses to everybody, but on the other hand, he receives the right to be able to use it and not allow anybody else to use it, except if they pay, for example, license fee or any kind of other agreement. So this, from one side, allows innovation to trigger further innovation, so everybody will know what are the inventions and how to improve it. But on the other hand, safeguards investments in research and development. And a patent is the right to exclude others of making, using, selling, or importing a patent invention for a limited period of time in a geographic area. So this, again, I want to mention, it's an exclusion right. So it doesn't mean that he has the right to use it. He has the right to exclude others to use it, or to make or to tell it. We'll see the difference with example. And actually, the patent is a legal document. As a legal document, it has a specific form. It is in that form, as you can see in the picture. There is a date of publication and the date of filing. Date of filing is the date that the owner of the invention has sent it to a patent office to protect it. Date of publication is the date when this is published to everybody. It doesn't begin from, it's not published from the beginning. Normally, it takes 18 months to be published. There is the applicant. The applicant is the owner who will make the money out of this patent. It's different from the inventor. I will explain the difference. There is a small abstract, so we can search patents and to read the abstract. There is an application number. The application number, for example, starts from EP, so it's for a European patent. If it is for Greece, it's from GR starts. And then at the end, it finishes in A1, A2, B1, B2. A means it's an application, B means it's a granted patent. I will explain the difference. And of course, there are the claims, description, and drawings. The claims determine what is protected by this patent. And the description and the drawings have the role to support the claims, to explain what the claims protect. So, applicant and inventor. This might be different people, but might be the same. For example, in a university, normally the university is the applicant because he has the right for the invention, but the inventor is the researcher who has done the work and who will get some benefits out if this patent goes well, if it sells. And of course, this changes from country to country or from organization to organization. For same, for example, in companies where somebody who works in a company signs a contract stating that whatever I will do will belong to the company, but he will have some benefits or some extra rights if there is an extra agreement. So, as you can see, there is a date of publication and date of filing. Please, if you have any question, you can interrupt me anytime. Normally, after that point, I can ask a question to everybody if somebody wants to answer. It's quite usual to do this question. I'll give you an example. So, let's say that I am a good scientist and I have discovered a new medicine for cancer. So I have done a lot of work. I have discovered this new active compound. It's fantastic. It will work, I believe. So in the morning, I'm drafting a patent and I am sending to EPO, European Patent Office, asking for protection. I'm very happy. I go to the Chamber of Commerce in the afternoon, and I'm so proud that I'm advertising to everybody that I will become a billionaire with my invention, and it is filed and it's applied, and this new molecule is fantastic. A competitor hears me. He goes in a little bit later, drafts a patent with this molecule, and sends to EPO the same day, but much later. So I would like to ask you two questions. The first question, who will get a patent? The first one, the second one, both, none. And the second question is, who will have the right to produce this medicine? The first one, the second one, and the second one, both or not? What do you believe? Any ideas?
The first one?
Both? I don't know. Both?
For which question? For the first or for the second?
For both questions.
Okay, thank you. Thank you very much for your answers. Well, for the first question, who will get the patent? As you can see, the patent doesn't have time, has date. So because both they have sent something on the same day, if it is inventive and novel and so on, but we suppose that they are, so both they will get a patent from the European Patent Office. So now, who will be able to use this patent, produce the medicine? The answer is none. Why? Because as we mentioned, the patent is an exclusion right. One is excluding the other one. One is prohibiting the other one to use the invention. So none of them will be able to do the patent and to use it except if they make an agreement between themselves and the cross-license. So one is allowing the other one to use the patent and so on. So have you understand this?
Yes.
Thank you. So what's the use of patents? First of all, patents are essential for allowing technology transfer and creation of spin-offs. We are working technology transfer of Ford, for example, and if there wouldn't be any patents, if if a lab doesn't have a patent, then this lab cannot disclose the inventions they have, the scientists, to the industry, because anybody could copy and steal it. Or otherwise, they need to have non-disclosure agreements or other type of contractual agreements. Patents protect against infringers. Infringers are people who will illegally copy the invention. Of course, it will bring back price, royalties, and licenses, but also we have to pay money for drafting and for protecting and for maintaining the patent system. Then, if somebody copies our patent, then we can ask again damages. So we can ask we go to a court and we can ask money back. Sometimes patents have value in time. So if it is at the beginning of a sector that's developing a sector, the first one or of the few first ones that will make the new inventions, and later they will make a lot of money for some. And of course, it allows globalization because they're published and everybody has access everywhere from the world. So their invention will be well known to everybody. Like, for example, in a journal. Now, okay, it is good to have patent, but what can be patented? And now I want to go a little bit in detail in this, because we receive a lot of time questions from academics if we can protect something and if it's patentable. This is in different countries, different things can be patentable, but more or less they converge. This, for example, from the European Patent Convention. European Patent Convention is the rules of European Patent Office. So it is Europe plus other countries. So patents, in general, patents are not granted for mere business methods, for rule of games, or for methods of treatment, diagnostics, and surgery of the human or animal body, or for inventions that they are contrary to order public or morality, or for plant and animal varieties. So, if it's something, a business method, or something, a mathematical calculation, it's difficult to get a patent. It needs a technical outcome. If it is a method of treatment, for example, for surgery, if a doctor could protect a type of surgery, nobody else would be allowed to do this surgery without his allowance, without his license. This is not allowed. Neither there are patents for bombs or for something that are illegal. So these rules protect the patent system from entering in these areas. Now, if we see Article 52 EPC, European Patent Convention, it says, among others, programs for computers, but also it has the word as such. Programs for computers can be patented. Of course, it's not that it's not allowed, but they need to have a technical outcome or to be useful to something, and this technical to be invented. Even a classification method, AI for classifying something from something else, separate something from something and classifying groups, they can be protected by a patent. So it's something, the idea that programs for computers or mathematical methods like AI cannot be protected is not real, but they have to be formulated in correct way in order to be presented with a technical outcome. Also, according to Article 52, patents shall be granted for any invention, so this means in all fields of technology, provided that they are new, so they should be new, involve an inventive step, and be susceptible of industrial application. Almost everything is susceptible of industrial application. It's a very general text that means that almost everything is possible to become patent, but they have to be new and have inventive step. New, when it's new, when it does not form part of the state of the art, and the state of the art comprises everything made available to the public by means of a written or oral description, by use or in any other way. So everything publicly disclosed, written or oral, is or by use is novel destroyed, and it has to be from a single PC. Single PC. What does it mean, single PC? If we have an invention of doing something, then somebody cannot combine some other inventions from prior art. Say, okay, if you combine them, it makes your invention not new, not novel. No, this doesn't work. It has to be only from a single PC, and could be broader than the claim or could overlap with the claim. For example, if I have a claim stating that I produced this medicine, actually this compound, by heating this material to 85 degrees of Celsius, and or between 85 and 90 degrees of Celsius. If there is another patent stating that they have produced something similar by heating it on 89 to 91, they are overlapping. So my patent is not novel because there is a place where they overlap the two claims. However, a new effect of an existing feature can give novelty. For example, a new medical use. We know that we have medicines. For example, the medicine for we have a medicine for diabetes. If somebody with an active compound, if somebody takes this, tries some experiments, and discovers that this medicine is good for something else that nobody else has disclosed, for obesity, for example, then he can make a patent and he can use this compound that's well known and is used in the past for obesity. So he gets a patent. So this, although it is known, the new medical use, for example, it is something novel, can be protected. Other things, if only one product is sold to the public, then it is not considered to be novel. For example, if you make a new lens for laser, and you sell one of these lenses, one of these lenses to another university for some reason because they want to try it, even only one, then you cannot protect afterwards. Also, if you go to an exhibition, you present an exhibition, and somebody looks around it, how it works, but he doesn't know internally how it works, novel destroying this disclosure is only for the features that can be seen. Also, if you show this lens to somebody else, but you have to ask him to sign an NDA, non-disclosure agreement, so he will know where, user know where it will say what it has seen, then this is not disclosure to the public. Disclosure to one or more persons makes no difference. It's enough to be available to the public if no one accesses it. I will give you an example. And when a document is available on a public access library, this is novel destroying. And here an example I had in the past, there was a professor who wanted to make a patent out of the work of a student. So asking, is it something new? Have you published it? No, it's absolutely new. Nowhere, I have never published it to anyone, anywhere. We have not written any program with this. It is fantastic, it works. Just my student had received his PhD based on this work on this molecule. Yes, but is this published in the university library as a PhD thesis? Yes, it is. This is public access library, so it doesn't have novelty. It hasn't considered. So we have seen that something has to be new. They also ask for an inventive step. So inventive step is that has to be not obvious to a person skilled in the art. Person skilled in the art is somebody who has no imagination, but not very well technology. So if it doesn't, it is obvious if it doesn't go beyond the normal progress of technology. But if you can combine documents or subjects from the past, from the prior art, to drive to the invention that you have. And in Europe, we test this by using the problem solution approach. I will show you the difference also with the states. What's the problem solution approach? You see, it's a little bit scary, this diagram, but this is how actually even a patent attorney would work with a patent examiner in the APO to justify if something has inventive step or not. Or on the other way, to destroy a patent by saying that, by proving that the invention doesn't have inventive step. So we identify if there is an invention, we identify the close prior art. The close prior art is something very similar to what we have today, our invention. But there are differences in something that exists in the prior art exists, but is not our invention, and from our invention, but it's the closest thing to our invention. We describe the features of the close prior art, and we identify the distinguishing features. What are the differences? What are the effects of this difference? And there is an objective technical problem. And this objective technical problem is solved only by these extra things that our project, that our invention has. I'll give you an example. So then we ask, would the skilled person look somewhere for a solution? Is the technology driving him to look for other item, other invention that could be combined with the close prior art to come to our result? If it's so, then it's not invented. And the criteria for close prior art, it discloses the combination of features that are the most promising starting point to arrive to our invention. And the criteria are to be on the same or close technical field, to have the same purpose, effect, use, and same structure and function characteristics. And I will go to an example. Let's say that our invention is a frying pan with an insulating handle. Nobody has discovered so far this time. But if we do a prior art search, we find the frying pan with metallic handle. So it's a frying pan, but you can keep it from the handling you will get there. And there is a cup of hot coffee, for hot coffee with insulating handle. So this is a different kitchen item, but with an insulating handle. So what's the close prior art? Both of them we can consider, depending on how we want to start from. From technical field, for a cooking item, the frying pan is a close prior art. For a kitchen item, for heat protection, it is the second one. For purpose, if the purpose is frying, is the frying pan. If the purpose is heat handling, is the cup. So both items have related features. However, it's easier to start from the frying pan to arrive to the invention than to start from the hot cup. So I'll go back. I will try to do this analysis. So the close prior art is the frying pan with the metallic handle. What is the difference of our invention of which is a frying pan with insulating handle, with the one that we found in the close prior art? It is the insulating handle. What are the effects of these distinct features that we are not doing when we are handling the frying pan? So what's the objective technical problem? How to use and how to use this frying pan without burning your hand. So the skilled person would look for a solution to the kitchen items, because they wouldn't go to the quantum physics, they would go something very close. And we identify there the cup with the insulating handle. Would this to be combined? Yes, because both are kitchen items, both they are having a cavity in order to put food inside, to put hot food inside, and both have a handle. And the second one has the insulating handle. So we can easily apply to this. We can combine these two items from the prior art. The frying pan with metallic handle plus the insulating handle from the cup to go to our invention. So it doesn't have inventive step. This is how we work to how to prove if something has inventive step or not. I don't know if it was complicated, but I want to give an example of how it will work and how, and because it's something very important, very difficult to judge. So now I'm going to something different. What is the procedure to the European Patent Office? First of all, I want to make to separate the patents, different ways to make a patent. One is through the National Patent Office. If we file and we proceed with the patent office, or some the Greek patent office, we apply for a patent, we file our documents, we do all the procedure, we get a patent only for Greece. If we go to European Patent Office, we can go to more. This is equivalent to national patents in many countries, and that then we can choose which countries to go. And there is also another system, PCT system, where it gives you 30 to 31 months to decide in which countries to go. In any case, even in the PCT system, you get a search report, but then it waits until you say that I will go to Greece, to China, to Europe. I will show exactly how it works. However, and there is no such thing as international patent. So I'll go, I have here the procedure, but I will do it in a better, no. I'll show it here. So here's a better, sorry, I'll present here, because I had another visual graph, but it doesn't seem to appear. In any case, we file the patent. There is a checking from the EPO, says, okay, everything is okay. We are going to proceed with the search report. In around 9 months, we received the search report stating that there are problems or not problems, or they has invented step, novelty or not. This is the opinion of the search of the evaluators or examiners. Then there is a publication. On the 18th month, the search report with the patent is published. So from that moment and on forward, everybody knows about our invention. Before, nobody. Before, it was a secret. It was kept by the European patent. We have 6 months to request for examinations. If we like the search report, or if we believe that they are right, we can proceed and pay money. If we believe that no, it was bad luck, somebody has done exactly the same thing and we have not found, then we drop the patent. Then there follows the substantive examination. And after the substantive examination, they decide if we can have our patent or not. And the substantive examination means that the examiners come to us, say, okay, you see, there is not in this claim is not invented because you have found this and this stuff in the prior art. And we answer to them, no, this is different from what we have done. So there is a going backwards and forward to the examiners and to us, and then we decide what it is. They decide actually if they will grant us the patent. After that, they grant the patent. So we have a patent on hand, and there is an opposition period of 9 months that somebody can come and say, no, we don't agree with this decision. We have to stop. Otherwise, if they don't do this here, they have to go to the national courts because the patent is going to be transferred to national courts. To Greek, to Cyprus, to Italy, to France. And this is through the validation national offices. Now there is a UPC, there is another procedure for some countries where it becomes one patent for many countries, but not for all Europe. And in the remaining countries, they have to be the validation report. But this is after the grant. Here, I would like to mention one thing that we want to observe, the third-party observations. I will explain what it is very soon, and it's something powerful if we want to stop a competitor or somebody who is doing something that we don't want to proceed with the patent. So the first step is to accord a filing date. The filing date means that somebody gets a date and the number. This is the filing date of the patent. in order to use it for whatever he wants later, or even to create a new patent and claim priority from this first filing date. What's a priority? We'll see in the next slides. However, for getting the filing date, this means that we need an indication that the European patent is sought, so an application, with the name of one applicant or one inventor, and a description. The description could be anything, or a reference to a single previous application, again, in any language, and this gives priority right. And I will give you an example. I am a researcher in Ford in Europe, and I am collaborating with a partner that is in Japan. So the Japanese researcher tells me, okay, I have prepared a publication. I want to send it tomorrow for publication. But we need patent. No, I don't have time. I have promised to the journal that I will send it by tomorrow. It is fine. I will send it to the journal. You don't have time to make a patent. In that case, we can ask him, send us the script, we take it, and we send it to the patent office, to the European Patent Office, for example, stating that we want to have a patent with all this information without paying anything. The next day, the Japanese guy sends and publishes the publication. For 12 months, I can come, claim priority from this filing date and filing number, stating that I have filed something, and although I have paid nothing, I have priority. And now I'm sending you a normal patent, and with all the details that it was required. And to be a normal patent, please ask for a patent. If he wouldn't have done this to send it to ask for a filing date and number and to claim priority, then the EPO would say, you see, you have a publication which is before this your filing of a normal patent, so this is not novel. But since we have sent the first one, the publication you have sent it by fax or by email, not email actually, by EPCP or the system that EPO supports, and to ask for a filing number and date, then they have no right, and whatever is from that, the first day till the second day, doesn't count as for the novelty destroying document. I'll give it to you in more details a little bit later. Yes. So, priority right. Priority right is a time limit right triggered by the first filing of an application. The priority right allows you to file a subsequent application for the same invention and to benefit for this subsequent application from the date of filing of the first application for the examination of certain requirements. So here we have a national application, but here it can be also the filing, this whole document, the publication I have already said. Okay, so we send this to the APO, and then we have 12 months either to ask a normal patent, or if many. So we see that we have for Germany, for UK, for France, for United States. So we file nationally or in the APO, wherever we like, something in one country, and then we have 12 months to go to other countries or even to the same country to have something more concrete. Here in this example, we saw that you can, in less than 12 months, you can claim priority from the first application. You can ask for a patent from the European Patent Office, and after this finishes, you can go to the different countries: Germany, France, Greece, UK. I don't know if you have understand this or if it was confusing. With this document, if something was published here, in the meantime, inside these 12 months, it doesn't count as novelty destroying documents. If we didn't have this priority, then this would be novelty destroying documents. It's a little bit difficult concept. So that's why if you have confused, please let me know to explain it a little bit better. Have you understand the concept of claim priority, of being able to file something without even paying for filing something, and then to have 12 months to file a normal patent? So again, in that diagram, at 18 months, we have publication. After publication, we have an application. It has not been examined yet. The patent is given after the grant. So, patent application, here I want to note, patent application is totally different from a patent. And if there is an A at the end of the patent number, A1 for example, it means that it's not yet a patent. So it has to be examined, it might be rejected. While then it has a B, B1 for example, this means that it is a granted patent. And the first one affects novelty, and the second the freedom to operate. We'll explain this a little bit later. And also, if you receive the sales report, as we mentioned, after the 6 to 9 months, we receive the sales report. The sales report has the documents that they are novelty destroying or inventive step destroying with different letters. And this is sent by the examiners, and we have to see if it is true or not and how we can respond to it. Also, I have mentioned that there is the third-party observation. When third-party observation is a tool for somebody who wants to stop the patent or to ask examiners to pay attention to the patent. This works from the date of publication till the day of even the opposition period. So after the grant plus 9 months. So we go to Espacenet and we see that there is a publication on our patent, but it is wrong. And all that doesn't allow us to work on our subject matter, it's got something a mistake. An easy way to ask the examiners to check on it and say that it's not correct what you have done, it doesn't have inventive step, or there is a document that describes this stuff exactly the same, but we have not seen it, is to use third-party observation. So anyone can file third-party observations online in English, German, or French for free, and only after the application has been published. This will be public and shall be taken into account and can be made during examination, opposition, and appeal. Two more things because we don't have a lot of time. One is freedom to operate. We have it's very often to hear what is freedom to operate and how you can check for freedom to operate. Freedom to operate is if we have the freedom to work of a patent. And what does this mean? As you know, there are several laws, as already mentioned, that they are not allowing something to be protected by a patent. For example, if it is for a bomb or if it is for surgery, these are not allowed to be protected by a patent. There is also the state of the art, stuff that exists and they are well known. It makes our invention not novel if it belongs to the state of the art. So if it's something not new, it cannot be protected. However, if something is new and inventive, for example, patent A, then it can be protected with a patent. As you can see, the circle with the blue color. But if somebody comes and says, okay, you see, I have found a specific effect on one small area of what you have in your patent, but this is a super wow effect, he can get a patent out of this. And this is a second patent, patent B. Patent B will be owned by the second guy, patent A from the first guy. Patent B doesn't have the freedom to operate, although he will have a patent. You will not have the freedom to operate because it is protected this area by patent A. And a simple example is electric kettle. The first guy who has discovered the electric kettle say, okay, I will make a kettle for heating water, which at the bottom part I will have some electrons, which by electricity become very hot, so they heat the water. So at the bottom part, he says that I will have metallic or other type of heating element. He gets the patent. This is the patent A. And then the big guy comes and says, oh, I have discovered that if I put ceramic bottom at the kettle, then this kettle doesn't get a lot of salt. So yes, it works, it heats the water, it's very fast, very good, but it also has an effect. It doesn't it doesn't scale. It doesn't cut a lot of salt on the bottom part of the kettle. So yes, it is something new, invented, and although it belongs to patent A scope, it has a square wow effect, so you can get a patent. But patent owner B is not allowed free because, as we mentioned, a patent is an exclusion right because he is excluded to work his right from patent A. And the other way, patent A can have kettles with the bottom part to be metallic or whatever he wants, except ceramic, because this is protected by patent B. This is the and why one has to ask permission from the second one. And there is a huge difference between freedom to operate and novel research. And what is this difference? Freedom to operate, we have to search for patents granted, existing, and valid, but for a specific reason. But for patentability, we have to search for novelty. So actually, for novelty, we have to search everything, publications, papers from all over the world, valid or not valid, because this will be novelty destroying. So there is totally different way to search for freedom to operate versus patentability. For freedom to operate, valid patents in the specific regions, checking one by one their claims if we belong to their scope. Patentability is to check if something can be patented, and this means search all the documents existing that they refer to this subject matter. And very, very briefly, patent search. Patent search, we should be able to do patent search using several tools, free or by payment. For example, Spacenet is the tool from EPO that allows you to do a patent search. And we have to search because to see if there is prior art, if it is what we are doing is novel and if it's inventive, but also identify what other inventors are doing, companies, identify new partners for licensing IP. We can see the value of the patent. For example, if I find that in a specific subject, many companies are fighting, goes to court for this to decide who will get the patent, this means that there are a lot of money. And very, very briefly, there are two ways to search. We are searching either by keywords or by sectors. Sectors is classification system is called. But here in this example, I saw difference. If we put lift arrangement, which show us both of the and the both examples in the bottom part. But if we put B67, B7, it will give us only bottle openings. So there is a huge difference what we are using to search. If we use classification, we focus on the sector. If we are using keywords, we might get something mixed. So the best way is to use both classifications and keyword search. I don't want to go further because I don't think we have any more time. I would like to thank you for the attention, and very, very briefly, stopping here, I'm going to show you another initiative that there is for the IP help desk. One or two slides of this. I'm stopping sharing and share another. How to do it. I don't know if you can see this
Yes.
presentation. Okay. Yes, just I want to mention there is the European IP help desk, which helps inventors how to protect something with the European patent. It is something that is offered for free from the European Union. Offers training. They have a very active website, offers training, and the helpline publications and ambassadors. I am also the Greek ambassador for IP. So you can go to the ambassadors, ask questions, and also you can call the helpline or send them a question. How we want to make a contract with this guy, we want to make an NDA, and they add us this type of clause. Is it valid? Is it not? There is a legal team there where they can answer these questions. And also there are very good publications for the IP. IP holders in all over the world. They have plenty of publications. And the next, they have several events. And the next event is on the 15th of April, a webinar for IP for future and emerging technologies. IP ambassador networks are ambassadors in many countries. You can find them by putting IP ambassador. You can find whom you can ask questions for different countries. Thank you. This was quite brief. Thank you. And please, any questions that might have, or if you have not understand what I was. Sorry. Thank you.
Excellent. Thank you, Kostas. Yeah, the floor is yours now. I think there are many interesting topics related to, so we have people from many different research initiatives on board today. We are over 30. And I think we are all in the middle of our research efforts, and there are many familiar words like non-disclosure agreements. How about disclosing something that is novel? Because in European projects, we are pushed to open access, sharing the results as we use public money, and we need to disseminate, we need to do public scientifications in open access. And then at the same time, we also need to preserve the novelty. So I think there can be many questions that the researchers have at this moment. So please raise your hand. This is the moment to ask the question you're maybe tackling in your project. We have Kostas right here with us, so go ahead. I pass the floor to our audience.
Excellent. Thank you. Yes, actually, it's very important to know how and when to protect and how and when to keep it open or to combine both of them, as in all European projects.
Spiros, go ahead as the first. You are unmuted, Spiros.
Sorry. So thank you, Mona, and thank you, Kostas, for this interesting seminar. So a question that comes to my mind is, what are the key factors to consider when deciding, for example, whether to protect an innovation through a patent or as a trade secret? I mean, in which case is one approach better than the other?
Thank you very much. It's very critical, this question, and very important, because the question is, should we protect by a patent? Should we publish it to everybody, our invention, or should we keep it as a trade secret? And the patent has a lot of expenses. It's really difficult to maintain, to go to a patent attorney to write, to draft it. So should we bother? Can we keep it as a trade secret? Trade secret is something that it has a legal form, it is a legal right. And as far as something, it has value and it's a secret. So the company or the lab keeps it as a secret by some methods, for example, passwords, not leaving to everybody. It has value, and this can be protected, and somebody can steal it and publish it. Then you have the right to claim damages. So again, it is a kind of intellectual property trade secret. So the question is, what should we do? Should we protect it or not? It is very simple answer. If you can, if you can produce this invention, and somebody can take it, reverse engineer it, and find how you have done it, how you have prepared it, then he can copy it. So you cannot keep it as a trade secret. Also, if you cannot enforce somebody to pay you money because he has used your invention, even if it's a patent, then don't patent it. Keep it as a secret. I'll give you an example. There was a big company, pharmaceutical company, producing a molecule as an active ingredient in pharma. After a while, the patent expired, and normally the companies, they protect the method for using this type of active ingredient. There was a very good method, so it was cost-effective, so they were protected. Another company came from China actually they import from China this material, this active material. So the first company goes and say, oh, you see, you are infringing our product because you are copying, you are using a method to produce our product, which method is protected by us in Europe. So you are not allowed to use this method anywhere in the world to bring something made by this method in Europe because you have protection. The company say, we don't know anything. We are importing to China. Chinese they are doing. Okay, they go to Chinese. The company says, Chinese, first of all, we are not doing anything bad because we are in China. You have to blame the company that is in Europe. But in any case, we are using a totally different way of producing. We are not infringing your method of production. The first company bought a lot of quantity of this material, analyzed it, and find small amounts of impurities, proving that they used their protected method of production. So by this way, they went to a court and they earned a lot of money. So if you cannot prove that they use your method and produce the product, then you cannot go to a court. So it's better to be a secret. Otherwise, you open the eyes for everyone. But if you can prove, if it's a way to prove, or there is no other way to protect it, because if somebody buys it, reverse engineer it, and finds how it works, he can copy it, then it's cannot do anything else. It's only one way solution to protect. I don't know. Have I covered your question?
Yeah, Kostas, yes, absolutely. Yeah, thank you.
Thank you. Any other question, please?
Magda.
Yes. Hi, Kostas. So, in the case, of a European research project where you might have more than one IPR beneficiaries, IPR owners, is there a best practice on how to split these IPR rights? Is there a...
Well, for the European projects, it's quite standard what the majority of the researchers are doing, or the research organization. First of all, there is the background IP. So whatever it has done before it starts the program, this background IP, it is owned by the person who has, or by the organization who has created in the past the IP. Then, during the project, some IP is created. Some partners, not all of the partners, but some partners are participating in producing this IP. Or in that case, the partners who are producing the IP are actually the owners of this IP. And these partners can have, with the applicants, we have the rights to make money out of it. And normally, we have the called invention disclosure, where before a patent takes place in protecting something with the patent, each patent describes, I have worked on this part with this way for in 10%, the other in 80%, the other another 10%. So each one will know what is the amount of what's the percentage that have contributed to the idea of the patent, the invention of the patent. One way is this. There are some other ways. If you cannot decide what are the percentages to be split equal to everybody or to everybody who participates. But in any case, there should be taken a lot of care during collaboration. For example, I am one researcher who works in that project, and I am sending them a material to another lab so they can check if it works, if it has any problem or so. So if I don't sign a material transfer agreement with the other lab, then and they discover, they do some measurements, and they come to some outcome, who will be the owner of this outcome? And is it the consortium with the owner? Is it the partner who has sent the material? Is the other lab? So for all of this, there should be agreements and documents establishing who has the right and what up to what point.
So an MTA is always a good idea then.
An NDA and an MTA.
MTA and MDA, okay.
Non-disclosure agreement and materials transfer agreement. Materials transfer agreement are required also for the protection of the lab. For example, I'm sending a radioactive material to another lab to test it. If the other lab says somebody has got exposure to radioactivity and so he has problems with health. He can ask damages or whatever through a court. So somebody who sells material has to be protected for everything.
Excellent, really good points. Do we have any other questions on the table to conclude the session for today? No hands raised. So as a but a message, I think that in all our projects, what we can take from today is that we need to, in all the projects by now, have a clear view of the key exploitable results and who are the IPR owners for each of the results. And maybe you are already conducting some patent search of patents that already exist in the markets and the products and processes you will be working on. And also, I think the IP help desk was a really useful tool to Kostas for also all the projects that were involved in the session today. So after the session, we will send you an email sharing the slides from today and also the link to the IP service website if you want to use the support for your IPR management in your projects. But with this, I think we can conclude the session for today. So thank you a lot, Kostas, for your super helpful insights. And I truly hope that this gives a good overview for all the partners in the different projects about what we need to do and perform in terms of IPR management related to our research. And also thanks to everybody taking this hour, sitting with us and learning more about the best practices for handling our patents. So thanks a lot. I will close the session here, and I will look forward to a new webinar with new topics and maybe also a follow-up session on IPR later on. So thank you everybody and have a really good afternoon. Bye.
Thank you.
Bye-bye.
Thank you.
Bye.